So welcome back to Building Safety Faces. Today I'm joined by Liam Spender. So Liam is very new to Twitter, but not new to the building safety crisis. So we'll talk about that in a minute. Welcome, Liam.
Hello, Matt. Thank you for having me. It's nice to be here and talking to you on Building Safety Faces.
No worries. And just for context, we're talking now 2 hours before the big unveil, the big announcement from Robert Jenrick in the House of Commons. So we don't know exactly what he's going to say, but it's been widely trailed that we're expecting a funding announcement, but we're also expecting a crushing disappointment for residents in buildings below 18 metres, which includes you. So can you just sort of talk us through maybe that starting point of what's going on with your building and how you got drawn into the building safety crisis?
Yes, happy to. So I bought my flat in a development in London near Canary Wharf in April 2019, and obviously had all the surveys done, got the fire safety risk assessment, which is what I understand is a standard document, and that didn't show any problems with fire safety. The building I live in is one of 9 on the site. They're all of fairly similar construction. It's just that they're of different heights. So one is less than 11 meters. It's only about 3 stories, and some are more than 18 meters. They're 7 stories. The one I live in is about 14 meters. It's 5 stories. The building I live in has cladding on the top floor, which is HPL cladding, but it's only on that floor. So didn't really think too much about it until May 2020, May last year, when another resident wrote to everybody and said, do you realize that the buildings have HPL cladding on them, and the government's issued an advice note saying all this cladding should be ripped off? And I thought, well, that's news to me. That's the first time anyone said there could be any potential risk. And I have to say, my first reaction, bearing in mind the cladding is outside the room I sleep in, is I don't understand why this is such a problem. It's on one floor. Even if it went up, I don't understand how it could jeopardize the safety of the entire building or stop people leaving in the way it did so tragically at Grenfell. I don't understand why the solution is, oh well, we have to spend an enormous amount of money to rip it all off. And the more I looked at it, the more I thought, well, this just doesn't make any sense. The policy seems to have been made for the worst case scenario in every case, as opposed to saying, well, no, the risk won't be the same for all buildings. So that's how I got involved in it, and it's snowballed because the agent where I live said, oh, we don't think your buildings will get an EWS1 because of the cladding. So that went on for a couple of months, and then last October we got an EWS1 with a B1 rating, but the agent says, oh, it's no longer a building safety issue, it's a health and safety issue now. We need to rip off all the cladding anyway, and we're going to try and get the money out of the building safety fund. Obviously, the problem there being my building, as with 2/3 of the apartments on the site are in buildings that aren't tall enough to qualify for the building safety fund. So that was a non-starter. But since the back end of last year, we've not heard anything about what's happening. So I'm sort of in a state of limbo over it.
I didn't know that part of the story, Liam, in terms of the, and we'll chat about that offline, I think. But yeah, if you've got a professionally produced EWS1 survey report with fire engineer recommendation that B1 is no remedial action required, that's a very strange approach for the managing agent to take, and I'll use that term advisedly, that it's strange. So we'll talk about, maybe this isn't one for the video, but I mean, certainly it's not unusual to see mangled interpretations of survey reports, either by the surveyors in inverted commas or by the managing agents that receive them. So yeah, that's a big issue. So, and then in your day job, you're a litigation lawyer. So what would be really interesting is to sort of get the legal take, obviously without you providing advice, of course, with all those caveats, but your take on where the law is in relation to this whole issue, and what angles there are or aren't.
Yes, I mean, my background is general commercial litigation. So I've trained and practiced in the City of London for the last 10 years. Most of my litigation experience has been representing large companies, so big tobacco, big oil, extremely wealthy private individuals in a range of corporate commercial disputes. So building safety, building law isn't something I've practiced in, but I've been looking at it, and there's a lot of information out there to read, and obviously having a legal background helps you to interpret that information, because you see a lot of people struggling with things like the Defective Premises Act and limitation and very technical issues like that. I mean, I think the bottom line on the legislative and the legislative regime and the legal options open to building owners in cases like this, the bottom line is that the system isn't fit for purpose. So the first problem you've got is generally there will be no contract between the people currently living in the building and whoever built them, because the freeholder may not be the developer. In most cases, it won't be the developer. So that deprives you of an easy claim. Instead of just getting into an argument about there was a contract and there was a breach, you have to find another angle to get access to be able to get access to a claim against the developer. And the claims against the developers are generally not they don't do the job. They're not fit for purpose, as I say. So you hear a lot of talk about the Defective Premises Act. So people involved in building work owe a duty when building dwellings, residential dwellings, to do work in a workmanlike, professional way that ensures that the dwelling is fit for habitation. And the clock on that claim starts running from the day the building is completed, whatever that means. It could actually be a date long before anyone lived in it, if it's practical completion. That may have occurred before anyone actually moved in. So 6 years just flies by, and obviously these problems have only come out following Grenfell. So in buildings like mine, which were built in 2001, limitation has long since expired, as has any guarantee, warranty, NHBC type of product issued. They normally only cover the buildings for 10 to 12 years. So a lot of people are finding that they're out of time, and they're finding those rules are very strict. I mean, for good reason. I can barely remember what I did 6 weeks ago, never mind 6 years ago. So if you're going to subject someone to the sort of scrutiny you're seeing at Grenfell, which is what goes on in a trial, you understand why there has to be a time limit on how far back you can go to bring claims. And then you've got other issues around the law being generally very pro developer, pro building professional. So the principle that you can't recover for, even if you have a claim under the Defective Premises Act, you can't recover for your economic losses. So losses measured only in money. You can recover for the costs of putting the building back into a habitable state, but you can't recover for things like waking watch costs or increased insurance premiums. And in some cases, they're more than the cost of the remedial works.
Yeah, I think if we look through all the sort of the legislation, even into sort of Landlord and Tenant Act, etc., it just seemed that the cards are stacked against leaseholders in sort of every avenue you look at. Really, you sort of look for a friendly avenue to think this is something we could. Oh no, that doesn't work. And I think so that overhaul of legislation, I think, is long overdue. And I think obviously campaigns have been going on for years around leasehold, etc., way before the building safety crisis. But and then obviously we on the legislative front, we've got the fire safety bill coming through. We've got the building safety bill coming. Now both of those seem to have gone a little bit sort of off the boil at the moment. Maybe we'll come back up again once we hear the announcement this afternoon. But what's your take on what is called the biggest overhaul of legislation in 40 years in relation to building safety? Have you really sort of looked into that yet, or have you been looking more on the sort of the the damages front?
No, I've taken a look at the building safety bill. I've been doing some work with since last December with the Leasehold Knowledge Partnership on their proposal for a levy scheme to make developers pay for the consequences of their mistakes. So I've done quite a lot of looking at what the government is trying to do to rectify the errors that have been revealed by Grenfell. My admittedly harsh assessment of the building safety bill is it takes a bad situation and makes it worse. So the fundamental problem, as I think you've talked about in your interviews with other people, is it's again applying new rules to old buildings, and it's repeating the same mistake the government's already made with cladding through its advice notes, which say in terms that buildings have to meet the standards of the 2018 building regulations, even if they were built in 2001, which is obviously an impossible ask for a building that's already standing. It's why we've ended up with this hugely costly problem. Is they're repeating the same mistake in the building safety bill. And to give you an example of how bad the building safety bill could be, as currently drafted, they may change it before it comes back to Parliament, but as currently drafted, it says the Secretary of State will have the power, after consulting with the building safety regulator, to change the classification of a building or any class of buildings. So, and if you read the explanatory notes, the bill says, oh, we intend to bring it in for buildings 6 stories or more, which may be more or less than 18 meters, but we might change it. So one day you could live in a building that's not classed as a high risk building, and the next day it is, and you have all the costs that go with making it comply with the new building safety regime under the bill. And if you ask me, that's just nuts. How can you live in a building where you don't know what regulatory regime applies to it, especially when you've bought it on the basis that it complied with whatever regulatory regime was in force when it was built? I mean, that stands to reason, doesn't it? It's when you buy it, you assume it complied with the rules in force when it was completed, when it was planned, and when it was built. So I think it's storing up trouble for the future. I think if you get another government that's more interested in chasing headlines about building safety rather than actually making buildings safe, and it's going to reclassify buildings left, right, and centre every time there's another fire that hits the headlines, it's a recipe for disaster.
Yeah,
And
then I don't know whether you've seen, but I don't know how closely you follow what's going on in Wales, but the Welsh government have decided to embark on a path which is effectively their own building safety bill, a different version, and their scope is everything that's multi-occupancy effectively from the word go. So, down to your sort of 2-story flat with 4 front doors in it will be within the scope of their bill. Now, on the one side, you've got clarity that everything's included. The other point is, how on earth do you do that at that scale? How do you? I've sort of described it a few times, even with the building safety bill in England is it's the equivalent of sort of putting double yellow lines everywhere but not having any traffic wardens. I'm just not sure that the enforcement through the building safety regulator and the HSE will ever be able to cope. I mean, they're starting with £16 million of seed capital effectively. And I would imagine, I don't know how quickly they're going to burn through that, but I would imagine probably even before they start, that money will have gone. So even if you just say licensing fees, well, we don't know what those licensing fees are going to be yet, but they're all going to fall back onto leaseholders again through the building safety charge. It's just one line item of cost. If an accountable person is fined, who pays the fine? Does that get put back into the service charge? There's so many unanswered questions and so many years worth of debate to go on that we can't even get the fire safety bill through, which is relatively simple. That's stuck in the mud. The building safety bill is orders of magnitude more complex than the fire safety bill. So I'm hoping I'll be retired by the time this actually receives royal assent. But it does. Back to your earlier point, it doesn't address building safety. It's more regulation, but we're almost missing the simple things, I think.
no, I agree with you. I think the court is being placed very firmly before the horse, and then the government's scratching its head and wondering why things aren't going anywhere. And to use your example about double yellow lines and traffic wardens, I'd say the building safety bill is actually going around lifting up parked cars and putting double yellow lines down and then putting the cars back and slapping them with a ticket. It's that sort of illogical, unreasonable approach. And if you ask me, I'm no expert in building safety, but surely it's a case of you can't make everything absolutely safe and zero risk for everyone. There's some risk in life, whatever you do. You have to decide what level of risk you're willing to accept and at what cost. And I appreciate it may sound cold and calculating because we're dealing with people's homes and people's lives. So there should be a high standard of safety, but not such a high standard of safety that it bankrupts people trying to reach it.
And back to your point with your building, we because of the mechanism of the fire at Grenfell and the inclusion of the facade, so that fire started inside the building, as most fires do, and made its way into the outside of the building, into the facade, and the rest is history. But because of that mechanism, pretty much everybody at the moment, including the government, are focused on the external wall. What is being completely ignored, or pretty much ignored, is what goes on inside the building in terms of evacuation strategy, fire stopping, smoke extraction, firefighting lifts, emergency lighting, all these other passive and active systems within a building that stop people from dying are being completely overlooked because we're all focused on the cladding on the outside. Now, it's not to say that the cladding isn't a problem, but I think in many cases it's a part of the problem. It's not the sole problem. But you would think from what you see in the press that it's the only problem. And I think that's a really dangerous narrative, and one that the government have done nothing to put right. In fact, they carry on, and I've kind of given up now with saying to media and saying to politicians, please stop talking about cladding, talk about building safety. But still the focus goes back to cladding. And
absolutely, it's become a shorthand for all these other issues. And I agree with you. In the worst cases, what's gone on with the internal fire stopping, fire breaks, and all the other systems you mentioned, fire alarms and smoke extraction, whether the lift works, dry risers, all that sort of bread and butter stuff, which goes back to the fact that the buildings weren't put together in the first place. You don't have to read the building regulations for very long to see it's a clear requirement that things are properly compartmentalized, and that's been there since at least 1985. If those rules weren't followed, I don't see how the regulations were followed. The issue, as you say, is, well, how do we make that safe at reasonable cost? Are the alternatives to basically pulling buildings apart and trying to rectify all those mistakes? Are there other things that could be done that would mitigate the risk to an equal or greater extent, but at far less cost? And I think that feeds into another issue. I'm sure we could talk about this till the cows come home, but another issue, because of the fact that leasehold is so rotten as a system, is the solution has been developed by people who hold duties like agents. They're responsible, managing agents are responsible persons under the fire safety order, and they've got one eye under the fact that they'll become accountable persons if the building safety bill ever comes into effect. So they want to cover themselves, and the way they're covering themselves is by taking everything to zero risk at the leaseholder's expense. If they were paying for it themselves, I doubt the solution adopted would be zero risk. There would be some risk because they wouldn't want to spend their own money on it. And then you've got this what I call a cottage industry of people going around basically trying to drum up work, and they're using the reports they're writing. In some cases, not in all cases, but in some cases, they're using their reports as business development opportunities. They're pitching for contracts to do the work, and the managing agents are happy to let them do that because they can slap on their percentage administration fee. So the more the works cost, the bigger the project management fee for them. And again, I say it's this should have been considered at the start, how it was going to be paid for, what level of risk is acceptable, what sort of business opportunity it was going to be. All these problems were foreseeable the morning after Grenfell.
Yeah, I mean, you raise a really interesting point there, and again, I don't have the full statistics yet to back this up, and I do like to. I'm a data person. I like to talk about numbers and things that I can validate, and to your point, I could stand up in a court and support evidentially. So this is still in the sort of the hearsay emerging trend sort of category at the moment, but anecdotally, we're seeing an increasing disparity between EWS1 survey results between private blocks and social blocks. And back to your point of the profit motive or the lack of technical expertise in terms of interpretation, why would or not even in private blocks where the developer commissions EWS1 versus when a managing agent does, you see these materially different results coming back. And my personal belief is, one is the quality of the surveyor that you appoint and their competence. And then secondly, how hard you push back on their findings. And do you read the report properly and say, no, you're wrong in section 2. This is the go away and do it again, or do you just nod it through and create another application to the Building Safety Fund or another section 20 opportunity on which you can get a management fee? And I think this has been reported to the government. I've done it personally and pointed them at this. The response has been less than overwhelming. So I know it's in theory being looked at, but again, unless you've got that sort of full detail, and that's why we keep sort of saying to people, if you've got your EWS1 survey report, send it to us, or your EWS1 form, so we can start to map out who are the survey companies, what blocks, what's their relative sort of pass-fail rate on everything they look at, and are there any particular surveying companies that are failing pretty much everything, whereas others that are passing pretty much everything? What types of clients are they being commissioned by? Those sorts of questions, so we can actually start to understand, is there something else going on here? And I definitely agree there are a lot of business development opportunities. It's a perfect scenario to grow your own work, mark your own homework, access someone else's money, and repeat without any real pushback, or aside from the fact that we are seeing more and more buildings being rejected now from the Building Safety Fund. But on that point, relatively little feedback on why they've been rejected. So we see, our building's been rejected and we're going to appeal. But when we say, well, what are the grounds for the appeal? Nobody really knows. It's just that we don't like the fact we've been rejected. Well, I would hope that if you do get a rejection from MHCLG, they would say, these are the reasons you have been rejected. Otherwise, I'm not sure how you can appeal.
Well, that's exactly it. You can't appeal without reasons. And I suspect that may be, although it could be down to lack of staffing and lack of resources, all the usual excuses you hear, which may be valid. But I think perhaps a decision is being made as a matter of policy. They won't publish reasons because it gives a sword for the disappointed applicant to stick into the government by judicial review, and it gives more angles to attack government policy. So perhaps they've just decided less detail is more helpful to them.
I also wonder how many of the 2,800 and so Building Safety Fund applications are ones like you alluded to, which are, well, we don't have a survey result that says that work is needed, but we think it would be effectively a good idea to try and get some money to improve the building. Let's put an application in. So they're almost vexatious applications in the first place. How many of those are there? Because all the Building Safety Fund say in their update is ineligible or withdrawn, but they're not giving any reasons why. So if 2,000 of the 2,800 were for buildings that were either B1 or below 18 metres and shouldn't have been there, that's materially different for the 800 that remain in terms of the amount of money that might be available.
Yeah, the 1 billion may go a lot further if we're only dealing with 800 applications. That stands to reason, and I think the government has taken some limited action. I don't know if you saw in December there was a letter from Neil O'Connor, I think he's the director of the Building Safety Programme. He wrote to interested persons saying if your building has a B1, it should not be in the fund. But obviously, how do they know a building has a B1 or not? The letter also alluded to the fact that extracts of reports had been sent instead of full copies. So anecdotally, you get the impression that maybe agents are seeing this as an opportunity, as you say, to use taxpayer money to improve their buildings, and what isn't paid by the taxpayer will be paid by the leaseholder. I certainly get that impression at the development where I live.
Well, we've seen written evidence from a large managing agent that should know better, that effectively just explains that and said when people have challenged that, said yes, we know that the building has a B1 and we know that technically no work is needed, but effectively we're going ahead anyway, and they've issued Section 20s, and you just think, well, how on earth can that be legal? It staggers me.
Well, it just goes to show how weighted in favour of landlord and the landlord and tenant law is, and agents are riding on the back of that. But that's certainly the explanation that's been given at the development where I live. Yes, we know it's got a B1, and we think it would be better to spend public money, taxpayer money, on bringing the buildings up to scratch in case the rules change in the future and we're left exposed. And when I've tried to challenge it, I've been ignored. And subsequently, I've been told to stop asking questions because it's distracting them from making the building safety fund application. So basically, shut up and pay the bill when it comes.
Yeah, it's outrageous. And I can't see, I can see a spate of civil actions as a result of this going forward. Because if we look at the implications of, if we just take EWS1 and say that the managing agent on behalf of the leaseholders appoints let's say an incompetent surveying company. That incompetent surveying company diagnoses the fact that this building needs a £5 million remediation project. 2 million comes from the BSF, 3 million comes through the Section 20 process, and then ultimately it's found that that work wasn't required. I would expect that as a group of leaseholders, you may well want to look through the civil courts towards the management company for negligence.
That's certainly one angle. I think the other angle is if the agent is trying to push through major works, Section 20 works, on the basis of the fact that they'd like to do works to improve a B1 rating, which is certainly what's been said to me at the development I live in, then you go back to the terms of the lease. The lease is a contract. The landlord is only entitled to expect payments for things that are allowed under the contract, and trying to make an improvement on the basis that you, the agent, disagree with an expert opinion from a properly qualified fire engineer because you don't like the opinion, seems to me to be very difficult to justify as to why leaseholders should pay under the terms of the contract. So that's what we call a Section 27 application, as to asking the first tier tribunal to decide whether the service charge demand is properly payable under the terms of the lease or not.
Yeah, that's a really key point on the fact that that particular managing agent used the term improve actually means something in law, doesn't it? And it doesn't work for them in terms of their argument, which I thought was a strange thing for them to do. And maybe sort of coming back to the building safety bill, I mean, I have multiple concerns with it, as you might have picked up on, but one of them is around the building safety charge mechanism, just to be able to say, this is a safety issue, therefore pay up within 28 days, with no real right of reply or opportunity to go to the tribunal to query. This is very much a fast track sort of backdoor to getting residents to pay bills. That ultimately, I think, as you mentioned, is based on, because we have a risk-based regulatory system coming based on the building safety case, it incentivizes, through the threat of criminal sanctions, everybody in a management position to have a very low appetite for risk. So the way that you mitigate those risks is to put systems in place and procedures in place that probably cost more money than you're spending at the moment. And the mechanism for charging that is you will pay within 28 days through the building safety charge. So if I was the accountable person, I would not take a risk with my freedom to save you a few pounds. So I'm sorry, I'm charging for the latest alarm system or the upgrade to the firefighting lift or the ripping cladding off or whatever it could be, because I'm not going to prison over this. So I can understand. So we've called really for a, we think we should be going back to a rules-based system with better rules that allows everybody to say, does my building meet the minimum standard? And we can raise that minimum standard in the way that we get with an MOT test on a car. You know, we don't have different views on risk about tread depth between MOT stations. There is a minimum tread depth for tyres, and they measure against that minimum depth. If it meets it on the day you pass, if it doesn't, you fail. And that's where we need to be with buildings, in my view.
Yes, and I think I've got a lot of sympathy with that view. I think that the reason we've ended up in the situation we're in at the moment is we moved to principles-based regulation, relying on people's judgments and good faith exercise of that judgment. And the industry's shown it cannot be trusted. So imposing a new principles-based regulation system with a direct line to leaseholders' bank accounts is asking for trouble. Now, I'm sure if you sat down and thought about it, you could come up with a way of making a principles-based system work, but you're going to need some, I think, two sets of things. One, some pretty heavy-duty, clear binding guidance as to how judgments are exercised, and proper enforcement behind that when judgments are exercised the wrong side of the line. And two, you're actually going to need something that makes the people who are making the rules bear some share of the cost, because that's the only way you're going to get proper cost control into the system. And I think as part of that, you're also going to need something that's missing in the building safety bill at the moment, which is proper routes of recourse against developers, agents, inspectors, architects who get it wrong. So things like they already have in Australia, which is a much more pro-resident system, where you've got warranties written into contracts that buildings will actually comply with building regulations, will actually be habitable, and there are duties on people involved in building works to avoid causing economic losses. If you put that sort of safety net in place, people are going to think twice about building a dodgy building, tick box exercise approach to compliance, because they know there will actually be, or could actually be, consequences.
Yeah, absolutely. Well, we're running a bit low on time, Liam. So this has been great. But before we finished, I was clicking around on your profile on Twitter and clicked on your link and found some fantastic photography. So tell us quickly about this, and presumably this is a sideline hobby that you do. But tell us what you're up to on the photography front.
Yes, well, thank you for looking. I appreciate all the visits I can get to the link, and I'd encourage others to follow it. But it is a hobby of mine for the last couple of years. I went on a trip to Japan, and I thought it would be nice to have a camera to collect the memories. So, and I sort of became a shutterbug, as they call us. Sort of got really into it, and people have said at various points, oh, they're good, you should try selling them as prints. So that's why I set up the website. And hopefully that means I'm not a one-dimensional person who just bangs on about law and risk and legal issues all the time. I've got sort of more of a hinterland, but I like landscapes, I like buildings, and looking at the details in them. It's just unfortunate that something I spent a lot of time looking at for pleasures, actually, I never realized the sorts of problems you could get with buildings if they're not put together properly. But I hope once lockdown's lifted and we can all move around a bit more freely, I'll be able to pick up the camera again and take some new shots.
Fantastic. Well, thank you very much indeed, Liam. Thanks for your time, and we've got everything crossed for a positive announcement at 12 o'clock today, which is an hour and 20 minutes away. So hopefully we'll get this video turned around quickly and out before the announcement. Otherwise, if anyone's watching it after the announcement, we didn't know what it was going to say. So for full disclosure. All right, so thank you very much.
You're very welcome. Yes, and I agree with that. We'll have to wait and see what he says. It's not a case of us not knowing what's going on. But thank you very much. It's been nice to speak to you.
Thank you.